Hey there, I'm estate planning attorney Paul Rabley, and in this video we're going to talk about what it means to avoid probate. Get a lot of questions about that. Paul, what's probate? What's the difference between probate and succession? If I have a will, do my heirs have to go through probate? What assets have to go through probate? What's probate? What's probate? What's probate? Get it all the time. So before we can talk about what probate is and what avoiding probate means, we got to talk about what probate is. So the best way to do that is to give an example that covers all the different kinds of things that people own. Let's talk about Alan and Alice Peterson. I use their names because their initials are AP, just like avoiding probate. It's how I remember things. Alan and Alice Peterson own 5 assets. They own a bank account. It's a joint bank account, like most married couples have at the bank. They own an IRA, individual retirement account. In fact, that account has to be in only one of their names. So let's say it's in Alan's name. They own a brokerage account, and since they're married, we'll call it a joint brokerage account. They own a vehicle, and they own their home. That's it. That's all they own. Now, Alan dies. Sorry, Alan. And now Alice has to start dealing with Alan's affairs. So she starts dealing with the particular assets. So the first thing that she does is she goes to their bank. My husband Alan passed away. We have this joint bank account. Is his account frozen? Oh, no, ma'am, it's a joint bank account. You can still write checks. The account's not frozen. She feels good about that. Then she goes to the brokerage firm where Alan had his IRA, his individual retirement account. She's worried about that. They tell her, no, Miss Alice, Alan, when he opened the account, he designated you as the designated beneficiary. And as soon as you get a death certificate, come back and we'll move Alan's IRA into an IRA in your name. You're going to be fine there. Alice is feeling pretty good. Then she brings up the brokerage account, which happens to be at the same financial institution. And that's a different story. And this is where a lot of the confusion starts to set in. Because the financial institutions tells Alice, well, as to the brokerage account that you and Alan have, they'll either tell her the whole thing's frozen, or we can give you access to your community property half of the account. But Alan's half of the account is frozen. We need to see a court order before our financial institution will authorize us to release any of those funds. Excuse me. Now she's saying, well, you know, his IRA was not a problem. So some of the backstory on that is with IRAs, people can designate beneficiaries, but with brokerage accounts, they can't. At least they can't in Louisiana. And if it's some national firm that permitted them to do it, you know, the state of Louisiana just doesn't honor some of those TOD designation, transfer on death designation. So she's stuck as to at least half of the brokerage account, if not all of the brokerage account. Then she wants to check on the vehicle because it might be in Alan's name only. It might be in the name of Alan Peterson and Alice Peterson, but she's going to be stuck there too because when she goes to trade that in, sell that vehicle, all of the names on the title must participate in that sale. So the Department of Motor Vehicles, when she looks into it, is going to tell her, well, we need a court order in order to take Alan's name off of the vehicle so you can sell it. So she's stuck there. And then they have a home. And she doesn't do anything for a while, but a couple of years after Alan dies, she thinks she needs to downsize. Maybe she wants to move closer to her grandchildren. Maybe she wants to move into assisted living. It really doesn't matter why she wants to move, but she wants to sell the house. And she pretty quickly discovers that she can't because all married couples, when they buy their home, they buy it in both of their names, and it takes both of them to sell it. Well, Alan's dead. So when that buyer hires a title examiner to examine the title of that home, that buyer, the buyer's title attorney, is going to uncover that the home is in the name of Alan and Alice. And so that home can't be sold until Alan's probate or succession is complete. So she's stuck there. Okay, so now we've gotten through the fact that Alan and Alice owned 5 different things: a bank account, an IRA, a brokerage account, a vehicle, and a home. Some of those things she was able to access, the bank account and the IRA. Some of those things she wasn't able to deal with, the brokerage account, the vehicle, and the home. So now, depending upon, number one, whether Alan had a will, and if so, what were the terms of that will, either Alice and some other people are going, depending upon whether other people are in the will or depending upon whether there was a will. Now look, real important here, the fact that someone has a will by no means means probate is avoided. It just addresses who's going to be a part of this probate proceeding. So after Alan dies and Alice discovers that she's stuck and she can't sell the home, she can't trade in the vehicle, and she can't get to his brokerage account, Alice and perhaps other family members will hire a lawyer like myself, and we'll get retained, and we'll prepare all of the appropriate court paperwork. We'll get the original version of Alan's will if he had one, and we'll prepare a bunch of paperwork, a list of assets, court orders, various other things. We'll get all the signatures. Sometimes we have to pass these court pleadings or court documents around the country because there's participants that aren't local, and so just more paperwork. Then once we get it all back and all the paperwork's prepared and signed by all the participants, then we go file it and pay all the court fees at the courthouse. And then the courthouse employees start doing their things, and those court documents make their way from the clerk of court's office up to a judge's office, where typically a judge's law clerk may review all of the court pleadings that we prepare and file. And if everything looks good, at some point a judge will sign one or more court orders, depending upon kind of the procedural steps that we take and the assets that are involved and some of the other factors. And then we'll get what's called certified copies of that court order, and we'll get that court order to the brokerage firm that orders them to remove Alan's name from the brokerage account and transfer those funds to whoever the appropriate heirs are. We'll get that court order to the Office of Motor Vehicles, and they'll take Alan's name off of the vehicle. We'll record that court order in the land records, or what's called conveyance records, where real estate records are held, and that will take Alan's name off of the title of the home, kind of freeing up that title so that Alice can sell the property, or Alice and others can sell the property, depending upon how Alan left it. So that court proceeding that takes place after Alan died, because some assets were frozen. If there's at least one asset that's inaccessible, then the survivors are going to have to go through this court proceeding. I can't do much about it. It's just the way that many years ago it was determined that our court system was going to be in charge of, when someone died with something in their name, our court system and judges are going to be in charge of making sure that the assets in the person's name get managed properly while this process is taking place, and then ultimately dispersed to the right people. A lot of people perceive that court procedure, or that kind of government supervised procedure, as being time consuming and expensive, and they assume that because, quite frankly, in many cases they're right. But nonetheless, it's a necessity when Alan died with a home and vehicle and a brokerage account in his name. Yes, Alice could get to their joint bank account, and as the designated beneficiary of his IRA, she didn't need any court orders for that. So they went through the court process. Let's say it took them a few months. Always costs at least several $1,000s, if not up and up and up, depending upon so many factors. Now Alice, as the surviving spouse, she has her will, and let's say her will leaves things to the 3 kids, and she has the exact same 5 assets. Months later, years later, after Alan dies, unfortunately, Alice passes away. So now the kids are thinking, well, we need to take care of mom's stuff. We're not sure what we need to do. Let's go check. And they find out, well, mom had a bank account, and mom had an IRA, and mom had a brokerage account, mom had a car, and mom had her home. So they start looking into those five things. They go to the bank, and the bank will say one of two things. The bank will either say, I'm sorry, your mom's account is frozen. It's just in her name, or it's just in her and your father's names. We need a court order before we'll release any of those funds. So the bank might tell her that. Or if Alice did what, quite frankly, kind of a lot of people do, Alice may, before she died, may have taken one or more of her children to the bank and added one or more of her children as authorized signers on Alice's bank account or credit union account, wherever that is. And so if Alice had done that before Alice died, maybe, and you got to check with your bank, but maybe the bank would have said, oh yes, child, I see that you are an authorized signer on your mother's bank account. We're not going to freeze the account. You can access the funds. So under that scenario, the child or children can access the funds. And that's what Alice wanted, because Alice didn't want to make it difficult for her children to pay for Alice's funeral expenses and other final bills that Alice may have. So that's how the bank account would have been handled. Alice had her IRA. She designated the 3 children as equal designated beneficiaries. No problem there. Financial institution says, when you get Alice's death certificate, bring that back and we'll set up new inherited IRA accounts for each of the 3 children. And we'll divide up Alice's IRA into the 3 children's inherited IRA. No court orders needed for that. But then the children inquire about Alice's brokerage account, not the IRA, but the brokerage account where some other investments were held. And the financial institution says, sorry, children, that account is frozen. Can't have designated beneficiaries on a brokerage account. You need to go through probate. So they get a little bit stuck and a little bit frustrated there. Mom had a car, same kind of deal. Can't sell the car, can't trade the car in. Got to get a court order to enable the Office of Motor Vehicles to transfer that vehicle. Now, I will tell you, we have something called at the Office of Motor Vehicles, they have produced what's called an affidavit of heirship. It applies only to vehicles, but if certain requirements are met and Alice dies and she has, let's say, a will specifically leaving the vehicle maybe to one or more of the kids or a grandchild or whatever, and all the children and the heirs sign these affidavits, then as to the vehicle, the Office of Motor Vehicles won't need a court order. But the financial institution needs that succession or probate court order to transfer the investment account to the children. And then mom has her home, and the kids want to sell it because they don't have any use for it. So the kids can't sell the house, and you can't put a child's name kind of, quote, on the house. So a court proceeding is required to transfer the home from mom, using her will to transfer it from mom to the 3 children as co-owners, so the 3 children can sell it. So that's the second probate. And here's where I'm going to tell you, probate in Louisiana succession, it's really the same thing. The other states call this court-supervised process of when somebody dies, transferring things from their name to the heirs. Other states call it probate. Louisiana, because we're different, we call it a succession. But it's really the same thing, and people use those terms interchangeably. So a lot of people ask, Paul, is there a way to avoid probate or avoid a succession? Because in Alan and Alice's situations, the family had to go through 2 different court proceedings just to get access to the brokerage account, just to be able to sell a piece of property, just to be able to sell or trade in a vehicle. And the family, children, survivors often feel like that's too much of a nuisance. Sometimes parents feel that way after they go through it with their parents or other relatives. And so it's kind of common these days for people want to people to want to arrange their estate to avoid probate. So how do you do that? Well, the misconception is that you can write a will and that avoids probate. Nah, doesn't work. Because if Alan had a will and said, I leave my home and everything else that I own to Alice, well, that wouldn't be enough after Alan died for Alice to be able to sell the home and get access to the brokerage account. If there was something in Alan's name when he died, like a home, like a brokerage account, a succession or a probate is going to be required even if Alan had a will. Because we got to go through all the court stuff to get a judge to declare it's a valid will and get a judge to order the financial institution to transfer the account and order in the property records that Alan's no longer an owner, that Alice is the only owner of that piece of property. So what's common these days is for people to, instead of leaving things to each other and to their children and to their heirs through their will, that's the traditional way to do it, but that requires the probate at each death. What's common these days is for couples, for example, Alan and Alice Peterson, to set up the Alan and Alice Peterson Revocable Living Trust. And only certain things that they own would get retitled to that trust. Some of the things that they owned, like their IRA, for example, it goes to the designated beneficiary. That avoids probate automatically. You don't have to transfer an IRA to a trust. In fact, you can't. But the concept is things that are titled in the name of Alan and Alice Peterson's trust. Things in a trust don't have to go through that court process when you pass away. They're not frozen. The financial institutions, the title examiners, they don't have to see a court order in order for those things to be transacted after someone dies. So what typically happens is, while they're alive and well, Alan and Allison Peterson set up the Alan and Allison Peterson Revocable Living Trust. And as part of getting that set up, the terms of their trust may say something like, when one of them dies, it's all stays in the trust for the survivor of them, and after they both die, maybe their daughter Diane is the trustee, but their 3 children are the equal beneficiaries of their trust. And they, as part of getting things set up, they retitle their brokerage account at the financial institution to their trust. We do the paperwork to transfer the title of their home from Alan and Alice Peterson to Alan and Alice Peterson as trustees of the Alan and Alice Peterson Trust. And now, when Alan dies, their trust says Alice continues to be the trustee, and things in a trust don't get frozen. So she goes to the financial institution, still has access to all of the brokerage account assets. She can sell the house the next day. No court orders necessary. She's already on the bank account and she's the designated beneficiary of the IRA. So she gets that even if that was in Alan's name. And then Alice dies a few years later, and then her daughter, as the trustee, can sell the house, can divide up the brokerage account assets, can sell the vehicle perhaps, if that's what's appropriate, all without going through the delay and expense of that court proceeding that was necessary when things were in the name of Alan and Alice Peterson when they died. So the idea behind that is different people own different things, and some assets that you are likely to own, IRAs are common, life insurance is another. Those things avoid probate by their nature as long as you have a designated beneficiary. Other assets that you own in your name, real estate, a home, stock, other investments, well, those are going to be frozen when you die if they're in your name, even if you have a will, and your survivors are going to hire lawyers like me to guide them through the court process, unless you transfer those assets to your trust. And then the trust really replaces the will. Things that are in a trust, the trust instrument dictates where those things go when you pass away. So all those terms that would have been in your will, they're now in your trust. And your will may not even be necessary anymore because there's nothing that has to go through the court process when you die to be transferred. your trust becomes really the controlling instrument. So that's a long 20-minute version of what it means to avoid probate. What is probate? What is the succession? How do you avoid it? How do married couples deal with that? What assets are subject to probate? What are not? Real important that you work with the right attorney, of course, who understands all of the rules that apply to different types of assets, so that everything can be structured just right, so your survivors it's gonna be easy for them to access and deal with things after you pass away without having to hire, quite frankly, a bunch of lawyers, unfortunately, like myself, just to gain access to what you have. All right, well, I hope that helps. Feel free to share your comments and experiences below in the comments. Feel free, of course, to hit the subscribe button. And of course, if you found this helpful, you can give it the thumbs up like button. That would be great. I'm Paul Rabelais, estate planning attorney. Have a great day.